It was a busy day at the Berkshire Mall in Wyoming, Pennsylvania, back in 2011. A woman named Lisa Cirillo was strolling through the common area, completely engrossed in her cell phone. Her eyes weren't on where she was going. They were fixated on a text message. Suddenly, her path veered, and before she knew it, she had tumbled headfirst into a decorative fountain. The water wasn't deep, but the fall was jarring, causing her significant embarrassment and, she claimed, a variety of injuries. Most people might brush off such an incident as a clumsy mistake, maybe a bruised ego and a wet phone. But Lisa Cirillo saw things differently. She believed the mall was responsible for her fall, and she decided to take them to court. This case raises a fundamental question. When you're distracted and injure yourself on someone else's property, who is truly to blame? The answer, as we'll see, is rarely simple. Cirillo's lawsuit against the Berkshire Mall didn't just appear out of nowhere. It began with the initial filing in the Court of Common Pleas of Berks County, Pennsylvania. Her legal team argued that the mall had a duty to maintain a safe environment for its patrons. Specifically, they claimed the fountain was a hazard, poorly marked, and inadequately protected. They sought damages for her medical expenses, pain and suffering, and lost wages, alleging the fall had caused permanent injuries, including neck and back pain. The dollar amount she was seeking wasn't publicly disclosed at the outset, but personal injury claims can easily run into the tens or even hundreds of thousands of dollars, depending on the severity of the alleged harm. The mall, naturally, pushed back, asserting its own version of events. But how do courts typically handle such claims, especially when the plaintiff admits to being distracted? The Berkshire Mall's defense hinged on a crucial legal concept: comparative negligence. They argued that while property owners do have a duty to keep their premises safe, visitors also have a responsibility to exercise reasonable care for their own safety. In this case, the mall contended that Cirillo's own distraction was the primary cause of her fall. The fountain, they asserted, was clearly visible, well-lit, and had been in that location for years without incident. They also pointed out that there were no previous complaints about the fountain's safety. Essentially, the mall's lawyers argued that Cirillo chose to engage in an activity, texting, that directly prevented her from seeing an obvious stationary object. This defense strategy is common in premises liability cases where the plaintiff's own actions contribute to their injury. But what exactly is the legal standard for reasonable care when you're walking around with your head down? At the heart of Cirillo's case, and most personal injury lawsuits, is the concept of negligence. In U.S. law, negligence has four main components: duty, breach, causation, and damages. First, the defendant, the mall, must have owed a duty of care to the plaintiff, Cirillo. Second, the defendant must have breached that duty, meaning they failed to act as a reasonably prudent property owner would under similar circumstances. Third, this breach must have been the direct cause of the plaintiff's injuries. And fourth, the plaintiff must have actually suffered damages like medical bills or lost income. Cirillo's lawyers tried to prove the mall breached its duty by having a dangerous fountain. The mall, however, countered by arguing that it met its duty of care and that Cirillo's own actions broke the chain of causation. This legal dance of proving and disproving negligence is where many cases are won or lost, but it's not the only factor. The concept of comparative negligence, which the mall invoked, is critical here. Most U.S. states, including Pennsylvania, operate under some form of comparative negligence. This means that if both parties are found to be at fault, the plaintiff's recovery of damages can be reduced by their percentage of fault. For example, if a jury determined Cirillo was 60% at fault for her fall and the mall was 40% at fault, and her total damages were $100,000, she would only recover $40,000. Some states even have a modified comparative negligence rule, where if the plaintiff is found to be 50% or more at fault, they recover nothing at all. This is a powerful defense for property owners and a strong incentive for plaintiffs to demonstrate that their own actions were not the primary cause of their injury. But how does a jury assign a precise percentage to someone looking at their phone? Here's what happens if a property owner truly fails their duty of care. Imagine a different scenario. A mall has a broken tile that's been loose for weeks, and several people have already complained about it. The mall management ignores these warnings. One day, a shopper, even one looking at their phone, trips on that tile and breaks their arm. In this case, the mall's negligence would be much clearer. They had actual knowledge of a specific, identifiable hazard and failed to address it. The argument of the shopper's distraction would still come up, but the mall's culpability would be significantly higher because they demonstrably breached their duty to maintain a safe environment. The critical difference is the foreseeability of the danger and the owner's knowledge or constructive knowledge of it. Cirillo's case was tougher because a fountain, by itself, isn't usually considered a hidden danger. So, how did the jury weigh these differences? During the trial, both sides presented their evidence. Cirillo's lawyers highlighted her alleged injuries, bringing in medical experts to testify about her neck and back pain and the long-term impact on her life. They might have also presented arguments about the fountain's design, perhaps suggesting it lacked adequate barriers or warning signs. The mall's legal team likely showed security footage, if available, demonstrating Cirillo's obvious distraction. They would have emphasized the fountain's open and obvious nature, arguing that any reasonable person exercising ordinary care would have seen it. The jury was tasked with considering all these facts, weighing the credibility of the witnesses, and ultimately deciding who was more responsible for the accident. This is where the subjective nature of reasonableness comes into play. What one person considers an obvious hazard, another might see as a clear obstacle for a distracted individual. And the stakes were high for both sides. A crucial part of many personal injury trials, including this one, involves expert witnesses. Cirillo's side would have brought in medical experts, like orthopedic surgeons or neurologists, to detail her injuries and prognosis, connecting them directly to the fall. They might also have hired an architectural or safety expert to testify that the fountain's design was somehow flawed or violated safety standards. On the other hand, the mall's defense would likely counter with their own medical experts, perhaps suggesting Cirillo's injuries were pre-existing or less severe than claimed, or that the fall couldn't have caused the specific issues. They might also bring in a premises safety expert to affirm that the fountain met all applicable codes and was not a hazard for a reasonably attentive person. These battle of the experts often sway juries, as they provide technical context to the subjective experience of the accident. How did the jury ultimately reconcile these conflicting expert opinions? A common myth in personal injury law is that if a danger is open and obvious, the property owner can never be held liable. While it's true that an obvious danger significantly reduces a property owner's liability, it doesn't eliminate it entirely in all circumstances. For instance, if an obvious danger is unavoidable, or if the property owner could have easily mitigated the risk with minimal effort, they might still be found partially liable. Think of a clearly marked but unavoidable patch of black ice at the entrance of a building where the owner failed to put down salt. However, in cases like Cirillo's, where the danger is a clearly visible, stationary object like a fountain and the plaintiff is distracted, the open and obvious defense is very strong. The law generally expects individuals to be aware of their surroundings. This distinction is vital for understanding why some slip and fall cases succeed and others fail. So, what was the jury's final word on the matter? After hearing all the testimony, examining the evidence, and receiving instructions from the judge on the finer points of negligence and comparative fault, the jury deliberated. Their decision was a significant one. They found that the Berkshire Mall was not negligent. This meant they believed the mall had fulfilled its duty of care to its patrons and that the fountain did not constitute a dangerous condition. This verdict was a clear victory for the mall and a blow to Cirillo's claim for damages. It reinforced the legal principle that property owners are not insurers of their visitors' safety, and individuals still bear a responsibility to watch where they are going. The jury essentially concluded that Cirillo's own actions, her distraction while texting, were the overwhelming, if not sole, cause of her unfortunate fall. This outcome sends a strong message about personal accountability, but doesn't mean all distracted walking cases are doomed. While the initial jury verdict went against Lisa Cirillo, that wasn't necessarily the absolute end of her legal journey. In the U.S. legal system, parties who lose at trial often have the right to appeal the decision to a higher court. An appeal isn't a new trial. It's a review of the original trial to see if any legal errors were made by the judge or if the jury's verdict was unsupported by the evidence. Cirillo's legal team could have argued, for example, that the judge gave incorrect instructions to the jury or that certain evidence was improperly admitted or excluded. However, appealing a factual finding by a jury, such as who was more negligent, is often an uphill battle. Appellate courts typically defer to the jury's findings of fact unless there's a clear legal mistake. In this specific case, Cirillo did pursue an appeal, attempting to overturn the jury's decision. But what was the higher court's perspective on the matter? Cirillo's appeal eventually reached the Superior Court of Pennsylvania. After reviewing the trial record and the legal arguments, the Superior Court upheld the original jury's verdict. They found no legal errors in how the trial was conducted and affirmed that there was sufficient evidence for the jury to conclude that the mall was not negligent. This final decision solidified the outcome. The Berkshire Mall was not held liable for Cirillo's fall into the fountain. The case serves as a powerful reminder that while property owners have a duty to keep their premises safe, that duty does not extend to protecting individuals from the consequences of their own clear and obvious distraction. It underscores the importance of exercising reasonable care in public spaces. This case, despite its seemingly simple premise, highlights complex legal principles that shape our understanding of personal responsibility versus premises liability. But what's the ultimate lesson you can take from this story? The case of Lisa Cirillo and the Berkshire Mall fountain teaches us a vital lesson about personal responsibility in the age of distraction. While property owners must maintain safe premises, the law also expects individuals to exercise reasonable care for their own safety. Texting, browsing, or otherwise being completely absorbed in your phone while walking can have real, sometimes costly, consequences, and courts are increasingly unwilling to shift blame for such self-induced accidents. Always be aware of your surroundings. It could save you a fall, a lawsuit, and a lot of trouble. If you found this legal deep dive insightful, consider subscribing for more true U.S. legal cases and courtroom stories told simply.